The idea for this program began when I received a most unexpected email. It was from a fellow named Billy Anderson, an old Concord name, but not somebody who I knew, whose photographic exhibit will soon be seen actually in the Concord Library. Is it up yet? Does anybody know in the main library? I think it's up on starting on the second floor. It is up. Okay. Hi, Kitsy. He sent me a picture of Louise Haldeman, the then president of the league, and then I'll tell you what then is, and asked if I knew who she was. I mean, who doesn't know Louise, right? It seems that in 1976, there was an election in Concord for 2 selectmen. One of the candidates running for the office was a current convict. That's right. Named, Valeka, right? Valeka, a resident in our local prison. The League of Women Voters held a candidates' night at the prison after more than 300 inmates had registered to vote. The issue, among others, was whether these men's votes would actually count. In the end, Mr. Valeka did not win. But Billy had made a film of the event, and he interviewed the candidates. He wondered whether anyone was around who recalled the gathering. Well, I had the pleasure of viewing this film. It's a rather rough and tumble, kind of compilation of things, but nonetheless, I recognized artists. I recognized, obviously, Louise. I recognized. Were you in it? Yes, I think you were in it. Yeah, and you were in it, and you were in it too. So I mean, there were all sorts of people were in it. I thought, oh boy, among others, as supporting, and so I knew that that this was something that we at one point in our history had taken quite seriously. Concurrently, I'm driving out to Knitting with Ingrid Detweiler, and she tells me about this fantastic talk that Di Clymer gave on restorative justice that she heard. And I thought, now there's a second kind of tendril that's all weaving these things together on restorative justice. And I began to pay much closer attention at that point, and I should have all along, to Colleen Kirby, our third speaker over there, to Colleen Kirby's fantastic work on the state league. She is our maven on prison reform. Thinking about forming this opening meeting, Ann Hayden, our membership chair, agreed that it would be a fresh, lively topic, and the board concurred last spring. We are therefore most fortunate to have these 3 distinguished speakers. My deepest frustration is that we do not have an hour for each of them because they are full of rich and engaging ideas. We have asked each to speak for 20 minutes. We don't have a little sign, the league sign saying 1 more minute, but we've asked each to speak for 20 minutes, leaving us time for questions afterwards. First, this introduction is far too brief given his stature, but the Honorable Judge John Kratzley graduated from Swarthmore College and subsequently from the University of Chicago Law School and Georgetown's Law Center. Besides serving as an Associate Justice in the Massachusetts Superior Court from 1987 to 2011, Judge Kratzley served as a justice in the Roxbury District Court for 10 years and in 72 and 73 a member of the Parole Board for Massachusetts, which means his insights into all of this are rich and detailed. His present association as an arbiter and mediator with JAMS punctuates his judicial talents. I will turn first to Judge Kratzley.
Well, good morning to all of you, and I want to thank the League for the opportunity to present with this distinguished panel on criminal justice and prison reform issues. There is a bit of responsibility that the League bears for the fact that I'm not on the bench today and here. Because in 1972, the League was very much behind the constitutional amendment for mandatory retirement of Massachusetts judges. And I remember voting for it in 1972 because there were a lot of old white men, and they were ruling against I was a legal services attorney working with poor clients, and they were ruling against my clients. I thought they should retire. So then my time came unexpectedly. You might even ask, how do I really have any reason to be here today, being a retired judge of a number of years now? Fortunately, the law schools didn't seem to care, and I still continue to teach at both Boston College and Harvard Law Schools, where I run a clinic that places law students with judges for an internship experience. And it's really through that clinic and through my students and through my ongoing interest in these issues that I've been able to keep up on what's been happening in the criminal justice field. So I do want to thank President Proctor and particularly Nancy Bucas, who chased me repeatedly about my availability to do this, for the opportunity to be with you. There are really, thinking about today and thinking about the issues you're going to hear about from all three of us, I'm going to go sort of to the several big themes in criminal justice and prison reform that are actively in people's minds and in the media right now. One of them, in fact, appeared in this morning's, the Metro section of this morning's Globe. That's the changes, and it really won't be my focus, but I think it's important for everyone to hear, and that's the changes in the offices of district attorney. Many of these reforms and changes in who gets prosecuted, who gets sent to prison, and for how long, are really rests with the powers of the district attorney. And the Globe article this morning, it's Adrienne Walker's column, makes the point that Suffolk County now has African Americans as sheriff, as the Democrat candidate, Rachel Rollins, for district attorney, and as police commissioner. And she's citing the kinds of changes that may well be coming in the future, particularly with Rachel Rollins, should she win. She has an independent opposition in Suffolk County, but should she become the new prosecutor for Suffolk County. And we know that Marion Ryan prevailed here, and I think, as you're going to hear from Di, Marion Ryan was a huge supporter of our restorative justice legislation, and would never, along with the League, would never, I think, have made it into the criminal justice reform package without her support. So the changes in prosecutors' offices and the changes in attitudes there, I think, are an important issue to be watching as we go forward. But the other theme where I'm going to spend more time is this fascinating sort of observation about pushback when there is significant reform. All of you know there was a major criminal justice reform statute, comprehensive, well worked out. I know Colleen's going to talk about the important role of the League in getting that bill done in April of this year. 6 months later, because of three significant tragic deaths that you all have watched and read about in the press, the death of Officer Gannon in Cape Cod, Officer Chesney in Weymouth, and the young man coming home from the hospital visiting his wife killed by a driver, has brought a reaction from the law enforcement community and from the public that's brought out two themes that we're going to have to watch and be thoughtful about, and the League will have to as we go forward. One is changes in the law regarding bail. While the new criminal justice statute has in it language that financial circumstances are, I mean, progressive language, financial circumstances are not to be a factor in setting bail. The Supreme Judicial Court said the same thing in the Brannigan decision. The governor filed legislation last week called an act, let me see what the title of it is, an act to protect the Commonwealth from dangerous persons. And it will change, if enacted, would change a number of the details, I'll talk about them down the road, in the bail system. And the second, which we have not seen, I speak more from a retired judge's set of concerns, we've seen something we haven't seen in, I think, for many, many years, a call for impeachment of judges who make controversial but within the law decisions, as well as new methods of removal of judges who, as you all know, have lifetime tenure here. We're one of the few states in the country, thank God, that doesn't elect judges and gives judges a lifetime absent improper conduct and punishment by the Judicial Conduct Commission or the Supreme Judicial Court. Our Massachusetts judges have lifetime until age 70 tenure and protection in their for their judicial independence. But telling that story seems to me more is the one I'd like to spend some time on this morning. So if we go back to the Criminal Justice Reform Statute, and you've got some handouts about the important provisions in it, I thought I would just quickly review them with a comment or two, maybe from my own perspective, about the significance of some of those changes. There are changes in juvenile justice. The age of juvenile responsibility was raised from 7 years old to 12 years old. Certain offenses that happen in schools, disturbing a school assembly, were decriminalized. Things that could have brought juveniles into the juvenile court system were decriminalized, and a number of additional language about diversion of juveniles, and that ties nicely with the restorative justice part of this act, are in the statute. I mentioned earlier the changes in the bail law, and the statutory language does parallel the Supreme Judicial Court decision in Brannigan that financial circumstances are not to be a consideration in setting bail, and that certainly has now come in this 6-month cycle to be a big consideration in this pushback to change some of our bail laws in terms of what the governor just filed last week. The more diversion programs, I know Di will cover this in more detail, and Colleen too. The most significant change for diversion programs for both juveniles and adults is the enactment of the restorative justice legislation. I think all of you are aware Concord is the founding community for C4RJ, Communities for Restorative Justice. I don't want to take any more time from Di in her presentation, but that statute now enables the restorative justice circle approach for offenders to be used in the courts. It was always, as we, I have to say, just a little more explanation. When I retired as a judge, I went on the board of Communities for Restorative Justice because I felt their work was so significant and offered such a meaningful option for offenders. Now that option is our program at the beginning was a police referral program. Now it's available to judges, probation officers, court clerks throughout the court system because of this important legislation. So that was another change. A significant change in the statute, in the Comprehensive Criminal Justice Act, was to reduce the number of years before you could seal your record. And that, of course, has a lot to do with reentry from prison and being employable. And so that misdemeanors may now be sealed instead of 5 years out, 3 years out, and felonies instead of 10 years out can be sealed 7 years out. And I think that was significant. Some of the mandatory drug sentences were eliminated. Now this, I think, and Colleen's going to know a lot more about this in terms of the push and pull for what got in that bill and what didn't, because the cry from both the judiciary and other criminal justice thinkers to eliminate mandatory drug penalties has been substantial. And yet I look at the crimes that were taken out in this legislation, and they're the drug crimes, they're relatively modest. And some drug crimes, new mandatory drug crimes, were created for fentanyl and carfentanil. So I'd be interested in her views, but it looks more like a balanced and less than full picture on eliminating drug mandatories. But some were. Possession with intent to distribute in several different classifications were changed from mandatories to simply discretionary sentences. Just a couple other things that are in that statute that are important. Fees and fines. You now have 6 months on probation, which you would not have to pay your preliminary probation fee. A year on parole, where you would not have to pay your preliminary parole fee. Again, part of helping with reentry and helping with the financial circumstances that so many offenders face when court fees and fines add on to the already existing responsibilities of being on probation and parole. And the other part, which is something I don't have all the details on for you, but in the last page of your handout are it's a whole list of future legislative tasks that are in the statute. They're commissions, study groups, regulations that need to be passed, that further implement parts of the criminal justice reform statute. Key among those, at least from a prison reform point of view, are things like compassionate parole, medical parole, the ability of very, very ill prisoners to be able to be released and save the Commonwealth immense amounts of money if they can be released to a nursing home setting or a family setting. But that requires additional new Department of Corrections regulations, along with regulations on solitary confinement, some new sets of regulations on mental health evaluations, periodic mental health evaluations, all important parts of prison reform, but needing regulatory changes, needing additional funding in state budgeting, which I think I'll leave to Colleen to talk about. But there, you've got a nice list of them, and it's surprisingly large, but most of those things on that last page result from enactment language in the comprehensive criminal justice statute. Not so noticed at the same time that the governor signed in April of 2018, not so often noticed at the same time he signed the Criminal Justice Reform Act, is a separate statute that came out of a study by the Council of State Governments on programs to improve incentives for release from prison. And that statute he also signed at the same time. It got very little attention, but it does increase the amount of earned credits that inmates can receive for participation in prison programs, and creates a greater collection of credit toward reduction of your sentence. The numbers are significantly larger than current, but it also requires a series of regulations and Department of Corrections implementation to make it work. And that statute contains new language on earned, let me give you the exact title, earned compliance credits during probation and parole. One of the additional concerns about our criminal justice system is the amount of time individuals who are released from prison have to spend on parole, if paroled, or probation, if the judge gave them what we call a from and after probationary period. And this new statute also increases the number of credits you can receive toward reduction of your time period on probation and parole for successful completion, which seems to me to make good sense. So there's all of this good feeling, some more balanced than others, some more positive than other parts about the components of that statute. And of course, in this room, I think the part we feel the most positive about is the restorative justice statute, because a number of us worked so hard, including the League and the folks involved with Communities for Restorative Justice, to see that put into state law and made available to judges. But within 6 months, we have these tragic deaths, and we have the law enforcement community calling for some changes, particularly in bail and potentially in how we select or even remove our judges. And I just wanted to mention what some of that legislation would do. As I said, the governor filed it last week. It's called an Act to Protect the Commonwealth from Dangerous Persons. And there are really two pieces to it that it seems to me will be watched closely by those who watch, including the League, that watch the legislative process. One part would be to change the process of what are called dangerousness hearings. This resulted from the fact that in all of those tragic deaths, the individuals accused were either on probation or on a low bail of one type or another. And so this is what the outcry was. Could these deaths have been prevented if someone had been more aggressive in watching this one individual who was accused of violations of probation, or if the judges had been more thoughtful in setting higher bails in those other situations? That has led to this idea that the dangerousness hearing, which has already existed in law, a prosecutor could, at arraignment, ask for a dangerousness hearing, and the results of a finding of dangerousness, which I think is the most sort of important point for here, is the determination that there would be no bail. Dangerousness statute is essentially a preventive detention statute, creates, upon a finding of dangerousness, the inability to have any bail. It's a no bail outcome. Prosecutors have used it rarely, in my experience, and the push is to make it much more actively and much more aggressively used. It requires a full-blown hearing, it requires evidence, and so the governor's proposal is to make it available at any point in the criminal process and not just at arraignment, to increase the period of time of being held without bail all the way from the finding until the trial. Right now it's 120 days that you're held without bail. Under the current statute, the proposal would increase it to being held for the full period once the finding's made. And I think the third change is to increase the number of crimes. The current dangerousness statute only has a limited number of crimes for which the prosecutor can seek a dangerousness hearing. The governor's proposal would increase the list of crimes for which the prosecutor could seek the dangerousness hearing. So there's one push there to address the bail situation by enhancing the use of the dangerousness hearing. The second part deals more with what we call traditional bail, because they're separate statutes. Your right to bail in Massachusetts without a dangerousness application is simply, by statute, a presumption of release on your own promise to return unless the government proves that you are a risk of flight with, say, default warrants or lack of any fixed residence or some type of open probation or parole. And then added to that statute has been this additional Supreme Judicial Court language, and now the criminal justice language, that financial circumstances are not to be a factor. The others are not eliminated, but financial circumstances can be the sole factor. But in terms of changing just what I call traditional bail, not the dangerousness process, there are a couple of proposals that would change things. One would allow the prosecution and defense to appeal. Right now, a bail decision at the Concord District Court that's unfavorable to a defendant can be appealed by the defendant and his or her attorney to the Superior Court. It's quite direct language, an automatic appeal to the Superior Court. And the review in Superior Court is de novo. It's just all over again. And this has caused some of my former colleagues on the district court to be very concerned, because they think they're setting sensible bails, and a day later or 2 days later, the judge in Middlesex or Superior Court or up in Lowell reduces the bail to a much lower number. So one of the governor's proposals is to allow the prosecution to also appeal bails along with the defense to the Superior Court. But the other, which I think will be more significant should this pass, is it changes the standard of review. Right now, the Superior Court judge is simply what I call de novo. They look at it as a brand new bail setting set of arguments from both sides. The governor's proposal would give the district court judge, the Concord district court judge, would give his or her decision weight, some precedential weight, and therefore they're using language like, unless there's an abuse of discretion or a violation of law by the Concord district court judge, the Superior Court judge cannot change the bail. So there are going to be some changes, arguably, if the governor's bill goes forward. Some potential changes in how bail is set and how it's reviewed for those that can't afford the bail given at the first level of the court system. The other provision that I think looks particularly troublesome to me, and again, this isn't law, this is just filed by the governor last week, but it's part of this swing from the enthusiasm about our criminal justice reform efforts back towards some serious law enforcement concerns prompted by these tragic deaths. But the other part would be a change in the law to allow a police officer to make an arrest on the spot for violation of the terms of your bail release. Often when an individual gets a bail, say at the Concord District Court, they may also have some terms and conditions, such as report weekly to the Concord District Court Probation Department, or attend a drug or alcohol program. So you can have a bail with some attached conditions. Don't go near such and such a person. Stay away from such and such an address. Violations of conditions of bail have always, and today, need to be enforced by the probation department, who have to get a warrant. This would change it to allow a police officer to make an arrest on the spot for observing a violation of a condition of bail. For example, seeing someone in a neighborhood they weren't supposed to be with, or around a child that they weren't supposed to be around. They could be an arrest right made there. That seems to me to be problematic, given the kinds of discretionary actions that might be taking place. So those are some of the changes that are in the wind because of just within 6 months the shift from enthusiasm about this important legislation, and then what often happens in the political legal scene when there are tragic events that motivate some pushback. The other thing I wanted to comment on briefly, just as a retired judge, is the to me really shocking development of the impeachment process, the impeachment call for one in particular, and maybe a second, of the judges who had set some of these low bails on individuals who then got involved in subsequent criminal activity or alleged criminal activity. This just has not been seen before. It has not gone anywhere. So the particular judge I'm thinking of, Judge Feely on the North Shore, was motivated largely by certain Republican legislators and some public outcry over a sentencing in a drug case. And the second one is the judge who actually had set the bail for the individual who was the driver. I think he was killed as well in the accident that killed the young father. And this it's just particularly disturbing because these bail decisions and these sentencing decisions are all within the discretion. There's no outrageous outside the law act of any of these judges. And then the other part of it that actually may be something the league will wind up, that these impeachment ideas have really not proceeded in the legislature. But the one that I think the league will keep an eye on, I'm sure, is the call for some type of periodic review of Massachusetts judges, like a 5-year review by some type of commission. And of course, all sorts of issues suddenly pop into your head. Who's on the commission? Are these disgruntled lawyers? Are these? Is this going to shift with the political wind as terms of who the governor is? Would we want the governor's counsel, who does approve judges now, with all the questions about those members? Would we want them to review judges periodically? So it's just another outcome that may have some movement forward of this sudden sort of change in our in the conversations about criminal justice reform and prison reform. So I think I'll stop there. That gives you, I think, a good overview. We have the promise of some very progressive prosecutors on one hand, changing some of the decision making at the prosecution level, and then we have this shift with concerns about the bail system and how we review our judges. Thank you for the chance to be here.
Thank you so much. Encouraging and sobering. Can you all hear back there? Are we speaking loudly enough for everyone to hear? Yes, everybody can? All right, if not, there's 2 more chairs up here, so I would urge you to come and take them. Next, thank you. This is so informative. Next is Di Clymer. She needs no introduction. Everybody knows her, but she's a member of the League and head of the Restorative Justice Program. I learned from an oral history of Concord, which I encourage everyone to read. You can find it online. Just Google her name, and up will come this oral history of Concord and all sorts of other very interesting information. She was then a newcomer to Concord. I'll start that sentence again. I learned from an oral history of Concord that Di Clymer, then a newcomer to Concord, was first inspired by her connection with the First Parish Church to reach out to the prisons. Her initial task was to make curtains for the Concord Reformatory Infirmary. That was 1967. Over time, with Jean Bell, she crafted an increasingly educational outreach programs that have become really formidable and a model, not just for Massachusetts, but for the whole country. But she can tell you about her remarkable and distinguished work. It is a privilege to have you here.
Oh, thank you so much. Well, a lot of you know the story. I know so many of you have been here in Concord and part of the story of how the restorative justice program came alive here, and how prior to that Concord Prison Outreach began. Because we have 2 prisons here in town, this topic has been a core of interest for us. And it came about in the late 1800s because a group of people in Concord were upset that the young offenders were being put into the Charles Street Jail along with the adult offenders, males. And they thought that was terrible. And so they petitioned the legislature and asked to have a prison built here in town. And so in 1873, I think it was, the Concord Reformatory was built. The superintendent of the reformatory and his family lived in the home where you see the fountain, newly renovated fountain out front. And the young inmates would come through the hall and then into the prison. The townspeople were involved. There were people who were coming in and playing the organ for the chapel, and there were people who were coming in to teach the young people. They were allowed to go out at certain points of time and go into West Concord. Of course, there was also a financial benefit for us as a community because all of the produce, the piggery, and everybody else were the employees of the prison were coming from the town, so it was economically substantial. Anyway, the town has been unusual right from the get-go in identifying a needs and then getting a small group of people to make it happen. So that's a little background, and it's not surprising that in the late 70s we formed what is now Concord Prison Outreach, and that effort in a way was really the stepping stone to the restorative justice program here that started in Concord. It's a unique program that we have in Concord, and I'll talk about that just a little bit. But we had, during our work at Concord Prison Outreach with the educational programs in both of the institutions, the main prison, MCI Concord, and in the farm, the prison farm up on the hill, we discovered at that point in time there was no benefits for the inmates to take our courses. They did not get credit. They did not gain anything for taking the courses. So they really were the cream of the crop, taking the programs. They wanted to improve themselves. They were determined when their term got over, they would not come back, and so forth. And it was a little discouraging when time after time some of these inmates that we got very fond of and returned after they had left the prison. So we began to get interested in the re-entry process, and one of the programs that we heard about was something up in the Yukon, of all places, a restorative justice program run by Judge Barry Stewart. So we asked Barry Stewart to come to Concord and to talk about this restorative justice program. It was on a Tuesday evening. The weather was ghastly, just ghastly. And we looked at ourselves and thought, if we get 25 people here, this will be successful. It was held at the West Concord Union Church, and the seats were all taken, standing room only. So we realized that this was an interest in Concord. And then we formed a group where we didn't really, Jean Bell and Joan Turner worked hard to get a group of people, they were kind of the leaders of the town, involved in learning about what restorative justice offered. Restorative justice programs throughout the world are in little pockets. There's a good one in Vermont, there's one out in the western part of the state, in New Zealand and so forth. And they all work through the courts. So one of the people who came to our educational program was the clerk of the Concord District Court. And everybody, Carolyn Boyce Watson from Suffolk University, who was very knowledgeable about the subject, talked with this group. Everybody was very excited, and we waited. And we waited, and we waited for the Concord District Court to pick this up. And nothing happened. And so, finally, Jean and Joan convinced Len Weatherby, who was our chief of police at the time, and realized how important this tool would be for the community, convinced him to do this program through the police department. So, there we go. We're in a unique situation of working with the police, not through the courts, but through the police. And then, as you know, later on comes the community-based policing program, and this program just fits in perfectly. You can imagine when the time-consumingness of having the police involved in these cases that go to court. This is now reduced. I put out one page about C4RJ, and I hope that you have picked that up because on it is the website. And on the website, you will be able to see a 15-minute movie, a video about just how this works. It's a confidential program, very confidential. And so what we did was we got actors to help us put this video together. So you will see in this video just how this process works. The police refer cases to C4RJ. These are cases that are nonviolent, that don't have any domestic violent issues, don't involve drugs or alcohol. The volunteers who are trained, and we now have a staff of over 100 volunteers, they then do an intake with both the victim and two others. Volunteers do it with the offender, preparing them for the circle. In the circle, probably about 15 people. You'll see Christy in this video. She was part of doing the video. You will see how the offender, the victim, the facilitators for each, the parents. Most of our offenders are young offenders, although we have taken cases with adults. How they meet in the circle and process what happened. The victim speaks first and tells the impact for them. The offender speaks next and tells them what was on their mind when they did the prank, but it seemingly a prank turned out to be such a horrible situation for everybody concerned. The offender, I should say, stated again also in the video, the offender has to admit guilt to be part of this program. They have to take responsibility for what they have done. In the circle process, there's a repairment plan that everybody weighs in on. And the offender and the facilitators then need to actually go through that plan. They have to do at least 5 different things to repair the harm that they have done to this victim and to the community. At the end of usually about 2 to 3 months, they come back for a closing circle. The offender speaks first, and the offender talks about what they learned in going through this process. And then the victim speaks, talks about the meaningful apology letter that they received. Also, you realize, going through this process, that the other victims in the group, not just the one who had the harm done, but the other victims are the parents of the offender, who cannot believe that their child has done something so hideous. The kinds of crimes that we get are thefts, defacement of property, had a bomb scare at one point, we have had a lot of cases too which are breaking and entering, and often kids do these things in pairs or in groups. And the breaking and entering are when they take over a house, which, the family's gone on vacation, and they'll take over a property, and they'll be there and do some damage and so forth. And we have learned that we do one case at a time. If there is a group of people involved in these crimes, they come to our circles individually. So we have a circle for each one. So a lot of our cases, we're now in 21 communities. 21 communities. And Belmont and Chelsea, I think, are slated to come on next, so we'll be 23. But it's just such an incredible, it has such incredible impact for both the offender, the victim, the parents of the offender, the volunteers who are part of the circle and are working within the circle and so forth to make the case come out right. The police partners are our biggest allies. A lot of them were not initially. They had looked at this as sort of a get-off, free card. And they were not our allies. But they have gone through some of these circles, and they are now proponents. And our director of the program, Aaron Freeborn, who's our executive director, sits in the police circles and talks about some of the cases. And that is one reason why the growth has started. The other reason is because of the legislation that the League helps so much with. Now that legislation has been passed, and I left some copies of that up there, the legislation took 4 years to pass, but it basically promotes restorative justice practices. And it really validates the program, which is fantastic. But it also is presenting us with quite a challenge, because as you can imagine, with all of these communities having referrals to us, our 100 volunteers are not enough. So if you do have any interest, or you know of anybody who is interested in being a volunteer, I recommend it highly. I did it for a number of years. It's very meaningful. You get trained, you work in a team, you do it case by case, so if you're asked to do a case and it's not convenient for your schedule, you don't have to do that case, there's another one that you'll be asked to do. So it can be convenient, but it is just a really, as I say, a very rewarding experience to do. The police, as I was about to say earlier, the police have a wonderful chance now to really feel good about being involved with a kid who has done something wrong. They can direct them, they can offer them this program. They have to, as I say, they have to admit guilt. They can be sitting with them in the circle. But more importantly, they can see them out on the street afterward and just say, with a wink and a nod, good job. So it's really, it's a cornerstone, I think, now of the community policing effort. Just in kind of closing, I want to talk about the challenges that we as an organization, Communities for Restorative Justice, are facing. One of the key ones is that because it gets started here in Concord, and because the community was so enthusiastic about it, and we have so many trained Concord volunteers, we have some challenges of trying to get our mission into all, and an explanation of all of this into the other communities that the police have signed on for. So we need funding. And we're working hard to try and get the word out, to do outreach in the communities. We do things like go to the Rotary, we do things like meet for church forums and that sort of thing. But one of the most important things that we are trying to do just recently is to try and beef up our mailing list. So on the little sheet that I gave you that has the logo for C4RJ, there's the list of the 21 communities. And what we are going to do shortly is to send out a mailing to our mailing list, just to sort of update everybody as to what we're doing, what are the new things that have happened. And we want to expand that mailing list to all of these 21 towns beyond Concord and Carlisle, who already know us so well. And I don't know if you would be surprised, but I was surprised when I started thinking about who do I know in Boxborough, and who do I know in Lincoln, who do I know in Sudbury and Maynard and Weston and Wayland and all of these towns in Burlington. And I didn't know a lot of people. So I'm asking you, seriously, to circle the towns where you know somebody. And if you have their address, fine, but if not, we'll find them. Because we would really like to inform them about this program that is now in their communities, and they really ought to be participating as well.
Social media too, like Facebook.
Yes.
Like Restorative Justice, and
Yeah.
it'll go out on your Facebook.
Yeah, yeah. And the other thing that we are thinking, or we have been thinking about, is cloning ourselves. There are opportunities for more programs. We are, fast getting very familiar with Middlesex County, and they're coming on board. But we do have Wellesley as one of our communities, and that's in Suffolk. Not only are we servicing the 20...
Norfolk.
Not only are we servicing these 21 communities, but we're servicing more than that because the DA's office is referring cases to us. Oh. And so we are also in Lawrence and Lowell and other places too. So we are up to here, and we need some help. So we thank you for being part of the history of this organization and doing so much to bring it alive.
Thank you so much. Colleen Kirby provides all Massachusetts leagues with vital information about pressing prison reform efforts. I hope you collected at the front table now. You all have a summary, I think, of the key legislative that Governor Baker signed this past spring that was sponsored and encouraged by Colleen and the Massachusetts League of Women Voters. At the end of the packet, as Judge Crassley noted, are the initiatives yet to attend to, which Colleen will in part guide us. No one is better equipped to inform us about the League's invaluable work in this area. Colleen, thank you so much.
Well, thank you all for coming out, and I learned a lot from Judge Crassley, and I want your information so that you can let me know about these new bills, so that the League can jump on them if they turn into...
I have a copy for you.
Okay. Of course. And I also want to thank Di. I met her earlier this year because they had the annual fundraiser for the C4RJ was in Arlington, and they hoped to raise $20,000, and they raised more than double the amount, from what I hear.
Thanks to Di.
Thanks to Di. She did an amazing fundraising event. Unfortunately, the bill does not include any funding for restorative justice. That was pushed for, and it did not get into the omnibus bill, which we were very disappointed about. Anyway, as you've heard, on April 13th of 2018, Massachusetts passed an amazing criminal justice comprehensive bill, which 4 years ago, the advocates didn't even hope that it would have this much in it. It doesn't have everything in it, but it has an awful lot of good things. Massachusetts is taking a forefront in criminal justice reform. The League did take a role in many of the reforms, most of which were explained by Judge Kratzley, which should give me time to get through what I wanted to tell you, because I won't have to repeat what he explained. And I just want to see a show of hands. Did any of you speak with your legislators about restorative justice in the last 4 years? Yay. It's thanks to you and many people like you across the state that made this happen. This would not have happened without grassroots advocacy. And so I hope you can give yourselves a pat on the back, because really it's up to you and all of the other groups that got involved that made this happen. And why did so many people advocate for this bill? First, I want to just sort of paint a picture for you of why this was so important. This figure here, you see all these gray bars? This is the incarceration rate of every state in the United States. And the longer the bar means the greater the incarceration rate. Well, right down here at the bottom, this is Massachusetts. So we have the lowest incarceration rate of all the states in the United States. So isn't that fabulous?
Yes.
Hold your applause. This is how the entire world looks. These are all the nations all across. And you see Massachusetts is way up here. There are only 9 countries that have a worse incarceration rate than Massachusetts. Only 9 countries. So why is the United States doing so much worse than the whole rest of the world? This is a horrendous thing. We are socially, we think it's okay, obviously, but it's not. If you look just at NATO countries, that's Massachusetts, not the United States. That's Massachusetts, the yellow bar. These are the other NATO countries, the incarceration rate. So we have far more than twice as high. Well, this is the United States.
Yeah.
This is Massachusetts. So the United States is the top gray bar. The yellow bar is Massachusetts, and these are all the other nations in NATO. And you can see, compared to NATO, we have more than twice as many as the next state, which is the UK. But if you look at women, that's the green bar, Massachusetts. The United States is gray. This is just women incarcerated, and this is much more than twice as many. We have much more than twice as many women incarcerated in the rate. Back when Di was doing her curtains, 1967 for the jail, we had a much lower rate. The rate has increased since the 70s 4 to 5 times, just here in Massachusetts. So there has been a societal change, which means that we can change it back. We don't have to have such a high incarceration rate. Why are we locking up so many troubled and troubling individuals? Agreed, we know. Why are we locking up so many individuals? So here, it's not just the people that we're locking up. In Massachusetts, we're keeping in custody around 20,000 people, but we're keeping this brown part of the circle here are the people that are under probation and parole. So there's about 90,000 people that are under state supervision. So it's not just, and if you're under probation or parole, you're being watched. And that's why we have so many people going back into the system, because if you mess up, you go back in for whatever violations you're doing, which is why the judge is so troubled by having the police being able to be another set of eyes to watch over people and say, oh, you're going back in. Another troubling thing is, who are these people? One thing is, here you show these squares on the left-hand side. This is the proportion of people in our Commonwealth this is how many people are white, and this is, minority groups. And as you can see, there's fewer people in custody who are white relative to the proportion of our public, and more people who are primarily black and Hispanic, because the bar goes up. So there's a higher proportion that are in custody that are minority groups. Plus, in Suffolk County, I know, I don't know the proportion in other places, but I've heard this talk from Sheriff Tompkins, about 85% of the people in custody in the HOC and jail in Suffolk County have substance abuse issues, and about 42% have mental health problems. Are we locking up people because of, we have a lot of people we're locking up because they have substance abuse issues and get in trouble, or are troubled individuals and are getting into trouble. And the thing which I found very shocking, not having a legal background, is that 1/4 of the individuals in custody are being held while they're innocent because they're awaiting trial. So 5,000 out of the 20,000 people we are holding in custody are pretrial individuals, some of whom are only there because they can't pay the fee to get out. But as you see, there's a reason also why people are afraid to let individuals out on bail, because what if they commit are involved in a crime, whether it be an accident or some other thing, and then those people, are the judges or whoever let them out, are held accountable. Oh, and then the other point I wanted to make is that it costs around $55,000 per year to hold somebody in the jail or house of corrections. That's a lot of money taxpayers are paying. Are we getting the best bang for the buck? Are we actually allowing people to get out better people than when they came in? Are they being rehabilitated? The answer is probably not as much as it could be, because we have a very high recidivism rate. We have about 2/3 of people going back in after they're released. We have people who are being released straight from solitary confinement out onto the street. They haven't even stepped down to get programs before they go out. Now, this bill does change a lot of those things, but this is why it was so necessary to get this comprehensive bill. It took a lot of lobbying. It took the governor, the Chief Justice, the Senate President, and the Speaker of the House invited in the Council of State Governments, which is an outside agency, to study the system. They wrote a report that was released 2 years ago to look at Massachusetts and say, what can we do to reduce they only asked them to come in to reduce the recidivism rate, which was the one bill, the Council of State Governments bill that was released, which was a good bill, but it wasn't enough. It wasn't comprehensive enough. And that's when the advocates all got together. They formed a lot of informal groups across the state and said, we want more than just this one bill to be approved. So there were coalitions formed, hundreds of individuals got together. But as I said, the biggest change wasn't just legislative change, it's also changing hearts and minds to say we need to rehabilitate people so that when they re-enter, they can become good neighbors and productive members of society. So we do still need to keep an eye on this implementation. So that's what this list of 29 commissions, task forces, regulations that need to be provided. I gave you this list, and I'm hoping, because every one of these commissions need to have legislators on it, or their legislators are asking for people to sit on these commissions. And so I'm hoping that if you talk with your legislators about something, you can show them this list and say, are you on one of these commissions? Tell me about it. What's happening? Not only because you need to know, but also they need to know that there's still an interest, that we didn't just pass the bill and now it's over and it's like solved. We need people to have an eye and to say, what's going on? How are you involved? I asked my state senator, she's on 2 of these commissions. She's on the Justice Involved Women Commission, looking at how do we treat women in Massachusetts. And she's also on Restorative Center, which is a model program that they're going to be setting up in Middlesex County for people who are in crisis, either mental health or substance abuse crisis, because a lot of times people are thrown into the jail over the weekend because nothing's open from Friday evening until Monday morning. And so they want to open up a place called the Restoration Center in Middlesex County so that people can get taken right away. So they're in the process of trying to develop the program, and she's on that commission. But there could be, I don't know who's on these other commissions, and it would be interesting to find out. Let's see. So the reform planks, the league was very involved. We gave testimony on 12 different bills, which all got incorporated into the omnibus bill. If you look on the league's website, you can find out which planks we were involved in. We did not have to do a study on this bill because back in the 70s and 80s, the league was way out front. And in impact on issues, we had so many positions that were already there that we didn't have to spend 2 years to do a study because we already had the positions. One of the positions we had is we were completely against all mandatory minimums because we feel that the judges should have discretion over creating a sentence for an individual. That isn't what happened. They ended up getting rid of the low-level drug offenses, but they also did get rid of a lot of other mandatory minimums, like they shrunk the size of the school zones. I'm not going to go into the details here because I can't remember. There's so many different provisions, but let's see. Oh yeah, so we got rid of the school zone offenses. It doesn't do away, it does increase, as he mentioned, mandatory minimums for trafficking of fentanyl and carfentanil, and also it includes a new one for high repetition of drunk driving or operating under the influence. But it does allow an individual to be released before the end of their mandatory sentence so that they can be out on parole and probation and actually take classes to try and rehabilitate it. It includes incentives for people to try and rehabilitate so that they won't come back in later. The other planks that the league was involved in was increasing the felony larceny threshold. We had one of the lowest in the nation. We only had it would be considered a felony if you stole more than $250, like a pair of very expensive, one cell phone. Now that's been increased to $1,200. So that's positive. There's now also a mechanism to release, terminate ill, physically or mentally incapacitated individuals, such as our former Speaker of the House, Sal DeMacy. But the first person who's already come up under this provision was denied. So it's on the books, but is it going to happen to releasing individuals who are incapacitated and on their deathbeds or have Alzheimer's and don't even recall that they did a crime? Massachusetts has the highest percentage of individuals in custody who are over age 55, and this is because we did not have a mechanism to release people. Now we do, but we have to use it. We also have included a process to expunge records. We never had a process to get rid of a record, even if you were falsely accused of something and didn't do it. We still wouldn't get rid of the record. Now we at least have the process. Also, sealing it's made easier. We also can expunge records now for individuals under age 21, youthful offenders who've done something, and this won't have to follow them for the rest of their lives, giving them a second chance. The bill also reduces the criminalization of poverty so that it removes many fines and fees. It also removes certain restrictions to get occupational licenses. We were sending people, once you got a record, you couldn't become a hair cutter, because you had a record. There's like hundreds of different occupational licenses, so that's been decreased. We also, if you couldn't afford to pay a fine or fee, you would get sent to jail, and we would take $30 off every day. which is not very much. That's been increased to $90, but also you're not supposed to be held if you can't, just because you can't afford it. Let's see, now sealing, if your record is sealed, you will not have to tell the housing authority, or for certain licensing, or to get certain jobs, you won't have to disclose that. It depends on the type of job, but it used to be that it was really hard to get to move on forward with your life even after you'd served all your time, and supposedly were good with society. They also got rid of, it used to be that they would take away driver's licenses for many crimes, even if it had nothing to do with driving. Now it's limited. They're only going to take your driver's license away if you were caught doing something, reckless driving or something. Let's see. Oh, this is one of my favorite provisions, is that now the judges must take primary caretaker status into account. So that currently, it's like, you get taken away, sent to jail, your kids end up in foster care. Is that for the best of society? Is that best for the children who didn't do anything wrong? Now the judge must say, is there an alternative for a primary caretaker so that we can keep them with their children if they are not in danger to their children, and then the judge must write something down to justify, yes, we need to lock this person up because their crime was so heinous, or it's not going to cause undue harm to their children. So I'm really happy that was part of the bill. It raised the juvenile age to 12 rather than from 7. We did not raise the age. There was also calls to try and raise the age of what is makes the difference between a juvenile and adult crime. Currently, if you're 18, you're considered an adult, and that has stayed the same. But there is definitely the Citizens for Juvenile Justice Coalition is trying to push that age up to a higher age, 19, 20, 21. And there is currently, they did come up with a task force to look at, because it's the 18 to 24 age group that gets in the most trouble. And so now there is a task force to look at that age group to say, their brains aren't completely developed, they need to be treated a little bit differently. And then all of the houses of correction and jails must form units that are directed towards those individuals and to treat them a little bit differently, appropriate to their development into adults. We need to stop the school to prison pipeline, not criminalize behavior that happens in the schools. There are police officers that are now in most of the schools, but if you just act out, from now on, if it's not a crime, if you do it as an adult, it's no longer a crime if you do it as a juvenile. I mean, there's no good reason to send people to jail for something that you wouldn't send an adult in for jail. Keep the discipline at the schools and appropriate to the age level of the child. Let's see. For pretrial individuals, one of the big reasons for keeping people in jail is because they have to show up for prison. Well, we don't do the simplest thing like they do at the dentist's office to remind you need to clean your teeth every 6 months. You get a reminder phone call, you might get, other reminders. Well, now they have a pretrial services division that they're supposed to set up, that's one of the task forces, to give you reminder notices, send you a postcard, maybe give somebody a ride if they're homeless, and don't have the resources to get to trial. How can we keep people out of pretrial and yet still make sure that they show up? And there are a lot of things that we can do, and this pushes that. We need to expand the diversion programs and restorative justice programs so that you don't get a record to begin with and don't get into the system. How do we keep you out of the system and get you on the right track without giving you a record? Let's see. And then the final thing, well, not the final thing, but another important thing is to include oversight and data collection on solitary, people going into solitary. The UN says that if you're more than 15 days in solitary, then it's considered torture. We keep people in for far longer. We can put them in, we had been able to put them in for up to 10 years for disciplinary infractions if you threatened somebody within jails or within prison. So now you have to have oversight but we still can keep people in for a long period of time. But we did outlaw segregation for pregnant women and for juveniles. And also for those who have diagnosed serious mental illnesses, there's a specific list so that you can't say, oh, this person just has anxiety or whatever. So there's still, and also it used to be that if you were LGBTQ or an at-risk individual, they would automatically put you in solitary. And so they're no longer doing, or they call it segregation, but it's the same thing. So they no longer can do that. That was very important for a group called Black and Pink, which are individuals who had been in custody who are LGBTQ. And it's like, yeah, we want to be safe, but let us decide if we're going to be able to be out in the community, and why can't you put us in with other individuals that are similar? And then plus they now must give every individual who's put in segregation a plan so that they can work their way out of it. And it's not just throw you in there and you don't have a chance to get out. Another good thing is that parents are no longer they're no longer required to testify against their children as long as it's not something that happened within the home. Just like a spouse may not testify against the other spouse. It also creates mandatory police training in bias reduction and de-escalation practices, and it increases data collection and transparency of the system. And all of this comes with funding of $3.5 million for the first year, which is good, but it doesn't include the restorative justice piece. So that's why there's a lot of private fundraising involved. And this should decrease the recidivism rate. And as Will Brownsberger, who is the chair of the Senate Judiciary Committee, he and Claire Cronin, who was the chair of the House Judiciary Committee, they worked really hard to make this happen. And as Will Brownsberger said, we want to lift people up instead of locking them up. And we want to cut away the web of bureaucratic entanglements that make it hard to get them back on their feet. So that's the end of my part one. And then I still wanted to tell you what the league did and
Very briefly, okay?
very briefly, and how we got, the rest is
I mean, it's also
not as
interesting, but,
detailed.
yeah.
And then also about voting in prisons. So 4 years ago, I went around to my legislators and I said, what do you think is exciting coming up in the next session? And all three of them told me about criminal justice bills they were working on. Rep. Sean Garbely told me about the restorative justice bill that he sponsored in the House. Rep. Dave Rogers told me about parole reforms that he wanted to get incorporated, and they unfortunately did not make it into the omnibus bill, so there's still work to do there. And then Senator Ken Donnelly, who was still alive back then, he's the one that told me about how the 5,000 people sitting in jail who were still innocent until proven guilty. And that's what shocked me, was when I found that out. And so I called League and I said, you guys need to be advocating for these bills. And they said, well, that's great, but we don't have anybody to do that. And a few months later, I was still learning more about this issue because I was incensed. And I called them again. I said, you really got to work on this. And they said, well, we don't have anybody. And then I just said, duh. I can do that. So I volunteered. I didn't know anything about the issue. I'm not a lawyer. I didn't have a background in criminal justice issues. And I said, okay. And I met Carol Pelchat and Nancy Brumback, who are both just amazing, fabulous individuals. And they gave me a crash course on the legislative cycle, how to get involved, how to give testimony, how to write legislative research bills. And fortunately, Carolyn Lee is a specialist for good government, and she had already been advocating for getting rid of the mandatory minimum. So I jumped on that with her. Because we had all the positions, I didn't have to come up with a study, and we were able to give testimony on 12 different bills. And then I just started joining with other organizations across the state. I got involved in a mass incarceration working group at First Parish Arlington. I got involved with the Coalition for Effective Public Safety, which includes Prisoners Legal Services, and went to meetings with them once a month. I got on the steering committee for the Working Group for Criminal Justice Reform, which is an informal coalition that included hundreds of different organizations across the state, including, and we met at Mass Inc., which does a lot of research on various topics, including criminal justice reform. These groups, I got introduced to EPICA, which is an ex-prisoners organization, MORE, which is a mass organization for addiction recovery, Black and Pink, who I mentioned before, Citizens for Juvenile Justice, C4RJ, the Greater Boston Legal Service, Prisoners Legal Service, the Public Defenders, Greater Boston Interfaith Organization, and the ACLU, among many others. And all these different groups, we held forums, we did lectures, we went all across the state, we educated each other about our different specific topics. Many of these groups only had like one issue that they were interested in, or a few bills. The league, we ended up getting involved in the various planks, sort of as an umbrella interest. And so through this, slowly over the many years, there's Families Against Mandatory Minimums, which had been working on the mandatory minimum issue for the last 10 years. And we educated each other on what was happening, passed it along to our networks, and they passed it along to their networks. And that's how we slowly built up this coalition. Everybody was marching around on the same topics at the same time, so then we could have the timing on when to go talk to the legislators. When did we send out the mass action newsletter to say, go and talk? And then, yeah, we had the Day on the Hill. Other groups had lobbying days based on this. We did briefings at the State House to educate the legislators on these issues. Look, one of the fun things we did is that we brought a play written by a woman who was in solitary with a woman who had been visiting her, who was a playwright, and we brought this play that was traveling around the country. We brought it to Milford, which 2 years ago, the head of the Judiciary Committee in the House lived in Milford, and we knew that he liked going to plays. And so we held it. We held it at his local playhouse, and he came. We didn't know if he would show up, but he came, and so we were able to, he came and saw the play. He then stepped down and is no longer a House representative, but we ended up getting Claire Cronin in his place, and she was fabulous. And the one thing Claire Cronin did is that something which no other House leader of any committee, I don't think, has ever done before. She met with every single representative in the state and asked them about what they wanted to see in the criminal justice bill, what were their concerns, and she was able to incorporate and get them all involved, and that's what she then was able to present to Speaker DeLeo. And they were able to support this bill across the state. And that was a real hard effort on her part, but it was only also thanks to all the advocacy that people were doing, talking to their legislators, saying, go talk to Claire Cronin. We want you to be involved in this. Another fun thing that we did, the league was very involved in this, is that we had a big event in Arlington which brought in people from all over. And it was just before Valentine's Day this year. And we created Love, Justice, Valentines, and we got people to sign them and delivered them to at least 30 different members in the Senate and House just before Valentine's Day, and the bill was voted on in April. And then the other key piece was bringing in people who had personal stories to tell, to go in and talk with their legislators on various aspects of the bill. I'm almost done. And we also were able to we have one league member that lives in Speaker DeLeo's district. And so I called her up, only one, because he lives in Winthrop and Revere. And we just didn't have a league there. And so I called her up and I said, would you be willing to speak with your legislator? It turns out she was a debate champion in high school. And her mother had been involved in criminal justice issues. So even though she didn't know anything about them, she was very interested. And so we connected her up with another group of, there were some other constituents from other organizations, and the four of them went in and spoke with him. And she was only given her information like 5 minutes before she walked in the door, but she just hit it out of the park. She was just fabulous. So 2 years ago, the advocates were very disappointed that this bill did not pass, and because they kept waiting and waiting for this report from the CSG organization. But if this bill had passed 2 years ago, it would not have been as good of a bill. So it was good that we waited and we built the momentum and we had the advocates going in. But the biggest change for this legislation, as the judge mentioned, is not just having the legislation, because that's enabling, but the people have to make it happen. Some of the most powerful people are the DAs. The ACLU created this huge program to what a difference a DA makes, and we have had more DAs being challenged in this session than we have in like 20 years. We did put on a Middlesex DA race. Marion Ryan was the only DA that was not against changing the mandatory minimum sentencing guidelines. And so we're very happy with all that she did, and she also is at the forefront with using restorative justice in the jails. She did have a challenger, but whether the challenger won or Marion Ryan won, it would have been fine. But in some of the other areas, it was very important that there is this challenge, and there is still some communities are having a challenge most of the challenges were in the primary, but there's also some races going on. And if you know people in other counties and can help them put on a DA candidates night and to promote that people need to tune into this race, that's important. And then finally, just really quick, I just wanted to mention about voting in custody, because that's something the League is very involved in, voting issues. And it turns out that in the year 2000, up until 2000, as Di mentioned with her story about in the Concord jail, everyone who was in custody could vote. There are only 2 states left in the country where anyone can vote, whether you're in custody or not, and that's Maine, and I can't remember what the other one is. Massachusetts was one of those states until the year 2000, and then we had a referendum to take away the right to vote because prisoners were getting, getting power and advocating within the jails, and people were afraid, they're getting power and it could affect our local communities, so they took away the rights for felons to vote while they're in jail. But people who are in prison. But if you're in the jail awaiting trial or in the house of correction and doing time for a misdemeanor, you still may vote. But you still need to get your absentee ballots. It's not so easy to do. You can't tune into things, you don't have internet. So it's important, it's a good thing for the League to go in and try and help people get absentee ballots. It turns out that in Massachusetts, you do not have to be registered to vote if you're in custody and get an absentee ballot.
Oh, isn't that interesting?
Because we know who you are.
Yeah.
And where you live.
So it's right there where it's considered a person under special consideration. I mean, it's the same thing if you're living overseas or if you're in a military individual, serving your country. You also do not have to be registered in order to get your absentee ballot. So it makes it one step easier to get. You don't have to do it months in advance because we don't know. You may not be there anymore. So you can get your absentee ballot, but you need people to go in, and it's not so simple. There's still some steps involved in proving and in getting the town clerks to realize that is the law. We had people, because you can sign up as if your home is now the jail, because you're in between places where you're living or you were homeless before, you can call the jail as your home, and some town clerks don't realize that can be your home. So anyway, but and there is a group right now called Ballots Over Bars, and they're coordinating people to go in And they're still looking for people in, not in Middlesex necessarily, but in Barnstable, Berkshire, Bristol, Hampshire, Plymouth, and Worcester. So if you know people in those areas, they still want people to go in and help get people to vote. So thank you very much.
You can see why she's here. I mean, a dynamic and you know, obviously focused and determined woman. And it's a privilege, Colleen, to listen to all that you're doing. Time for questions. We have about 20 minutes for questions. So if there are questions, let's make sure we have a chance. Yes.
What's the difference between probation and parole?
Probation and parole. The
Sure.
distinction between
Sure.
probation and parole.
Probation is given by the judge after a trial and usually a finding of guilty, although there's some people on pre-trial probation, but it's a discretionary decision of the judge. It's a sentencing option. Parole is a decision by the state parole board of who can relieve prison early. And the state parole board has a set of, and there's some statutes, and then they have some regulations. Just simply in the House of Correction, up at Billerica in the Middlesex County House of Correction, your parole eligibility is half-time. So like at the Concord District Court, the maximum sentence anyone can get is 2.5 years in the House of Correction. You can't get a state prison sentence out of the Concord District Court. And the maximum is 2.5 years in the House of Correction per crime, and your parole eligibility then would be at 1.5 years. Now, not everyone gets a parole. So folks that watch this, particularly defense attorneys who are working with their clients, are watching what is the parole rate, how likely are individuals to get paroles. So parole is a discretionary decision of a state agency that goes to the prison, interviews the inmates, and decides who gets parole. Probation is a discretionary decision of a judge that you do not have to have a jail sentence, will allow you to live in the community, but you'll have certain detailed conditions you have to abide by.
Thank you. That's very clear. Yeah. Oh, Kate.
I just wanted to give a quick testimonial to restorative justice. Thank you, Di. Because 2 of my 3 children participated in that program when they were in high school because we're underage drinking. And it was a fabulous program, and I want to thank you for putting it in place.
Thank you for saying so.
Other questions? Yes. Mary.
What role did the Bar Association, if any, play, or the law schools in restorative justice, supporting it, and in the bill that was?
Could you all hear the question? What role did the bar? What role did the law schools play? And
the Bar Association.
And the Bar Association play in educating lawyers about the opportunities for restorative justice. Is that the way? Yep.
Roughly.
Okay. Roughly. Okay.
Who wants to take
You wanna-
it?
you- Well, I'll just say a couple things. I'm not aware, Di might be, I'm not aware of any bar association support for the restorative
Or
justice
lack of?
legislation. No, not particularly lack of. I think it was more, somebody didn't get to the Boston Bar or the Middlesex Bar and say, we'd like your endorsement. At the same time, just a conversation this week, the Harvard Law School, where I do run my clinic, the professor there is offering the first restorative justice class that I can remember and that she can remember in October. And she says she's got a long waiting list. So it's a little bit reminds me of the days of mediation, sort of growing, 20 years ago, that we would have this alternative dispute resolution technique in community-based mediation programs. I think this is what's happening with restorative justice.
Thank you. That's
They
very
were involved in the overall bill, though, in many planks.
The Bar
of it.
Association was?
Yes, the Bar Association, I know that Mass Bar and the Boston Bar were involved in advocating for many different aspects of the reform bills.
That's a pretty
Oh,
powerful
that's
lobby.
that is a
Yep.
powerful lobby. Cindy.
Is there a biggest reason why we have such a high rate of incarceration in Massachusetts? Say? Is it because of recidivism, or is it because of our mandatory minimums, or is it another reason?
Well, it
Could
is
you all hear that question? Okay.
Yeah, well, it is a historical thing that the reason that why did the United States start locking up more people. Part of it was mandatory minimums became popular. We had the huge war on drugs. We had 3 strikes, you're out laws. We do have, because a lot of people with minority communities are most efficiently policed. There's some studies that were done by Mass Inc., and it's not so easy to see this picture, but this is Fields Corner, and they've shown that almost every street has multiple people who have been sent to custody. So there's certain communities that are very heavily policed, and so people get picked up in those communities, and then it starts to become part of life.
Was it also the closing of mental health?
I'm sorry?
Was it also the closing of mental health institutions?
Yes, I'm sure that also plays a role, and also, what do we do with people who have substance abuse issues?
So it's just as a follow-up, so if you compare to the NATO countries that have a lower, is it because they send troubled people that would to a different place? Do they have more social services?
Yes.
So is that
Yes, it's a different social, it's a different social, what's acceptable and what do we do with troubled individuals, and troubling individuals. Like even Anders Breivik, the guy that killed all the children of political, in Norway, yes, and they killed the children at summer camp where a lot of the politicians sent their kids
Yeah,
were
their
there,
children, right.
and other people. But even for him, their maximum sentence is 19 years. But then you get another 19 years. I mean, he's never going to get out of custody because it was such a heinous crime. But still, it's not considered, oh, you just get thrown away for life. He's going to be looked at again every 20 years. And it's like, well, is this still warrant staying in? And I'm fairly certain that he's never coming out because he's definitely not all there.
Not necessarily rehabilitatable.
Right.
Dee.
But
I don't have a question, but I have a couple of suggestions. One is our 3 experts form the greatest roadshow available on this topic. And I know that we're filming it, and I would suggest that not only do we have it on our website, but that a copy of it is given to, we can also have a URL if other local leagues want to just refer people to it, but if we had a copy that was to the state as well as to all of the other local leagues, because the League of Women Voters has been very involved in this process. The other thing my second suggestion would be to DIE and your fundraising efforts. Since the league has been involved in it, you may want to contact, or through Meryl Kessler, the executive director of the state, be able to contact all the members of leagues in the local leagues where the restorative justice program already is in existence.
In other words, as a kind of an alliance with the league,
Well,
reach
not
out
just
to
for
our,
life, but an outreach
right,
for fundraising.
right, for fundraising and for information.
Right.
Right, did you all hear Dee's very good suggestions back there, because they're important? Thank you. I mean, they're really important. We'll figure out, we have a new website coming up. Thank you, Nancy Brown and others. And so with that new website, that's the kind of thing that we should be able to do with alacrity, is my hope. Ann?
Yeah, I'm curious if there's anything in there about oversight of private groups that are either running the prisons, own the prisons.
yeah, we do not have privately owned prisons in Massachusetts, but we do have private organizations
groups,
that
yes.
service
Right.
them.
And are doing the bidding of either the Department of Justice or the Department of Mental Health.
Yeah, I'm not
Like
familiar.
Bridgewater. Specifically.
Specifically, exactly.
Yeah.
I mean, these questions are.
So there's no, I just want to know.
Oh, I'm not
Is there
sure.
any language in there?
I don't know. I don't know that detail.
John, do you know?
No, there has been controversy about the treatments, well, but several different parts of the Bridgewater facility. You've got the mental health treatment center for those that are committed as sexually dangerous persons, but you've also got the 35A 30-day civil commitment that anyone can, probably most people perhaps in this room are not even aware, but you can go to a district court, like the Concord District Court, on behalf of a member of your family who is drug or alcohol addicted, and have them involuntarily committed for up to 30 days to a treatment program that's also sort of loosely part or physical plant is located at the Bridgewater facility. That program, which does use outside contractors, does have its controversies as far as the effectiveness of it, the length of the duration of it, and whether it's effectively actually rehabilitated or treated in that short period of time. That's not in the legislation.
Yeah, but there is one piece in there's a new legislation for substance abuse, and they are setting up a study to study involuntary commitment commission for non-court involved individuals with substance use disorder.
Back there, I saw a hand. Yes, please.
I was just curious, the ACLU is very active, they developed that wonderful stuff on knowing your DA, and they made it a much more interesting race in Middlesex for sure. And one of the big issues between Donna and Marion was data. And Donna was really pushing hard for data, and Marion was a leader in getting this stuff done. So it's a really fun race. And I heard you talk about solitary information or data about who's in solitary. So what's going on with data collection, and is that something the league is going to be asking about? I know that's detailed, but it just
No, it's important detail.
throughout.
Yeah.
Yeah, well, I
Colleen?
heard from Marion Ryan that in order to get like a better data system, it would cost like $14 million to get something happening across the state. That was one thing. The other thing is I know that Mass Inc. is focusing on the data piece. They are trying to push for that, and that's one of the things that these 29 different commissions and committees
Right.
is all about, is getting data and oversight out. And so that's one of the things that we as league members can be saying, what do you know as a legislator? Who's on these commissions? What are you going to do? When's the report coming out? Yeah, just keep this, say that we are interested as taxpayers. We want to know what's going on.
Dave, back there.
This is really a follow-up to, I think, Dee's observations earlier. To my ear, anyway, Colleen's report at the end of various people, herself and others' role in bringing this omnibus bill to pass is a model tale of how you create critical mass when you don't have anything to start with. Most extraordinary. Joy to my ears, frankly. It's the sort of thing that it strikes me one wants to have in mind in future initiatives. The creativity necessary, the energy, the persistence, really, over years, I can only say, big smile on the face.
And a thank you, absolutely. Kitsy, you had a question. And
Yeah,
then,
it was really to die. I'm thinking about the individuals who go through the restorative justice program. Were we not to have it, what would be the alternative for most of them?
could you all hear that? Okay,
I was thinking about the fact that we do have restorative justice. I'm wondering what would be the alternative for the individuals were we not to have it, which doesn't come up as much, and I know many of them are young, so.
Yeah. Well, the individuals that do go through it and complete the process correctly, I mean, complete it satisfactorily, and that's 99.9% of them, they will not have a record.
Okay.
And that is absolutely huge, especially
It's
for a
huge.
young person who is going on to higher education, jobs, employment, and so forth. They do not, that's not on their record at all. If they didn't go through the program,
And is it personal choice or a?
well, if the community sufficiently knows about the program, it's such a confidential program that a lot of people in communities do not know about it. But if you knew about the program in the community and surprise, surprise, your son and daughter did something really stupid and ended up with a felony charge, if you knew about the program, you could advocate. You could say to the police, would my son or daughter be eligible for this program? 9 times out of 10, that's not the case. The community isn't as aware of the program, so they can't advocate themselves for it. But the police are ever so much trying to get more cases done in this way. It saves a great deal of money. It is so much more satisfactory to everybody involved. And so they are delighted to send as many cases as they possibly can to C4RJ. And they are involved with it, of course, so that's another bonus. They do pay, the police departments in participating, pay $1,200 a year to be a member. And unfortunately, our DAs are not paying, and that's one of the things we hope to change, because we are getting some of our bigger and testier cases through the DA's office. So
That's fascinating. Claire and then Dory.
Not everybody has the energy and so on that Colleen has, but I want to say that any one of you could join the State Legislative Action Committee.
Yay, Claire!
If there's something you care about and you think the league is not doing enough on it, they're not, testifying for bills that you know about and so on, you could be the person doing that. Just contact the state league and say, I want to be a legislative action specialist.
And you'll get the training and the support. Dory.
Yeah, my question is really for Di, and it's so clear how effective this program is.
Yeah.
But it's also clear from the presentation by Colleen that the number of residents in our prisons are coming from probably from districts where there are not restorative justice.
Yeah.
So how are you moving, and where can leagues help? And then your comment about having one league member in the Revere area, and I expect that the proportion of people who are living in state facilities now is higher from Revere than it is maybe from Concord. So how does it get expanded? Is there a state movement behind the state league, Di?
Well, this legislation is a huge help
Yeah.
because now that validates the program for everybody concerned in criminal justice work. So that is one of the reasons why all of a sudden we're having towns sign up like crazy. They want to participate. I think we have got to go through a growth analysis, our organization, and try and determine what we can do and can do well. Our program, as I say, is unique, being a police-based model. So other communities, like Len Weatherby talked to me recently, said that he was going out to a community outside of Buffalo that wants to do a restorative justice program that's police-based. So we are encouraging cloning. We're encouraging other groups to get involved and learn how we do it. We had just in the last few years, we did a highly successful program in Malden, in a high school in Malden. And that was so successful, we ended up putting a handbook together. It's something you can actually download if you go onto our website. And it is a how-to book for schools to implement a restorative justice program in their schools.
Where there may not be strong league centers in some of these towns, just as your relationship with this began with the church here in Concord, is there any reaching out to churches in some of the areas where there's a high rate of incarceration? To get it stopped
only
before it
informally.
starts? Informally,
Yeah.
But that's a terrific idea.
Yeah,
I
it is
wonder
a
if
good
that's
idea.
an avenue where there might not be a League of Women Voters active group in Jamaica Plain,
Yeah.
let's say, or parts of Boston.
So Dory is thinking about other social organizations like churches and others that
Yeah.
might help to forward
Yeah.
you know, this
That's a very
kind
good
of
idea.
a program,
That's exactly, yeah.
yeah, to help communities perhaps manage this
Yeah.
without sending young kids into serious
Yes.
prisons.
Yes.
Maybe
Where
PTAs.
are the yes,
Well, yeah,
yes,
that's
or the,
very
yes,
good.
yeah, the parent teachers associations where they exist.
Yeah.
Yep, Colleen.
I have one quick thing to add, and one of the organizations that was involved in this, whose piece did not get included in the bill, was an organization called Resolve to Stop the Violence Project, and they're trying hard to get a restorative justice program put into the Department of Corrections, which is the prisons. And
Yeah, that would
the
be-
Commissioner Turco is interested in the program, but the thing is to get the funding to make it happen. And if anyone wants to get involved in getting restorative justice into the prisons, I can put you in touch with Shar Simpson.
Wally, our last question, go ahead.
Suggestion and question. As far as outreach to towns, if you're not doing it, the Mass Association of School Committees and the Mass Municipal Association both have annual meetings where there are a significant number of school committee members and town officials. And having some sort of a presentation in those venues would be great. And there are 100 presentations in the course of 3 days, so I think you could shoehorn your way in.
Yeah.
I'm always curious with some of these things like the bail fairness, the implementation, and who's responsible, what's the procedure to determine somebody's ability to pay a bail? Like, it just seems so out of the realm of, you're in a courtroom and you're sort of in this position to set bail in a short period of time. How do you?
Yeah, well, that's part of the legislation, is to figure out a mechanism to do that. Whereas currently, it's basically the DAs say, we want this bail for this person, and the judge says, okay. But the judge specifically sets the bail, but it's usually at whatever the DA says. So now they are gonna have to have a process where they say, is this affordable? I mean, they already do some process to say, does a person get to have a lawyer? Are they indigent so that they can get a lawyer without having to pay anything? Or waiving a fee. I think that's also included to that if you're a youth, that they do not have to pay for a lawyer now. But I don't know the specifics, but I do know that they have to develop them.
Yeah, let me let me clarify that a little bit. And I think anyone who now visits a district court like our Concord court, and someone is being newly arraigned, the most important event of that arraignment is obviously the bail determination. And we know from ample studies that your likelihood of being released on bail dramatically affects your likelihood of staying out at the end of the case. So that's an significant adversarial event. The appointment of counsel does give you the right, if you're indigent, to an attorney. There are attorneys who are there, the bar advocates, the public defenders, and my students are reporting consistently now, which is different from practice when I began years ago, that these attorneys are given an opportunity to talk to the client and make a bail argument in opposition of the district attorney. So it's not really just what the DA wants. It's an adversarial proceeding in which the defense attorney, the newly appointed defense attorney, has the opportunity to bring financial resources information out, to make some phone calls, perhaps to the employer, perhaps get some family members there, and make a reasonable position, a reasonably adversarial argument for setting bail. So you're right that it's still a highly discretionary judge's decision what the bail should be, but I do think it's a more adversarial process perhaps than it used to be.
So again, we hear this wonderful word, mediation. Yeah, yeah.
The other thing I wanted to point out in terms of expansion under the new statute, expansion of restorative justice programs, and the excitement of this district attorney race that we just had here in Middlesex County, the first day of the training of the 24 new assistant district attorneys at Marion Ryan's office, this was 2 weeks ago, we presented on the restorative justice program. And we presented on And that was at her invitation, and she made quite a vigorous speech about her commitments to restorative justice, because these young assistants who are going to wind up in the Concord court and the Lowell court and so on, they're going to make, under the statute, the decisions about referrals, post-arraignment, pre-arraignment, post-arraignment, at sentencing. All these new options are really going to be guided by these new young assistant district attorneys. So it was really significant for the director of our C4RJ and myself, Senator Jamie Eldridge, to be there and talk about what we hope they will be doing to expand the use of restorative justice.
Thank you so much. You can certainly ask questions afterwards of these folks, but I want to thank you for coming this morning. Our work, obviously, as a league is never done. I mean, if there isn't one issue, then there's another that really demands our attention. From a local perspective, tonight there is a public hearing on the warrant at the townhouse. So you probably all received your warrant in the mail yesterday. If you did not, it'll be there, I hope, for you this afternoon. Artist Boardman will conduct a Concord Town Government meeting the following Tuesday, this is Wednesday, the following Tuesday from 1 to 3 in the trustees' room at the main library to review this warrant and to look at local issues that are of importance to all of us. At our home, and this is open to all league members, on the 26th in the evening at 7 o'clock. Our address is 57 Sudbury Road. We're right in the center of town. The board will be looking at these warrant questions to make recommendations. So anybody who wants to come and be heard, the board is the one that votes, but you're all welcome if you have a strong point of view or a strong feeling, having listened to the hearings or attended them, and feeling that the league should take a particular position. Please do not hesitate to write us or to attend. Then, this coming September 30th, the evening before the Concord and Carlisle, 2 evenings before the Carlisle, an evening before the Concord Town Committee meeting, at 6 o'clock after the Patriots game on a Sunday. The balancing we do. At the Trinitarian Congregational Church, Cass Sunstein, an eminent Harvard law professor who also taught for 27 years at the University of Chicago Law School, will be speaking.
And a resident of Concord.
That's exactly right, and a Concord resident. Will be here. There's his book called Impeachment. But it's not about impeachment. It's whether, although it may be, it's really about, can our democracy fail? You know, are we at risk of losing our fundamental democratic principles of law and rule of law? Cass is brilliant on this question. I really urge everyone to bring friends, neighbors, everyone you know, because listening to him talk about it, exercising and engaging in this dialogue should be fantastic. There's more food, so please don't leave any on those tables uneaten. Before you leave, I hope you will remember to take this sheet, put your name on it, put your email address, your telephone number, and indicate which committees the league is involved in which you would like to participate or at least be connected and contacted on a regular basis. And I promise you we will follow through. Stefan. Yeah, there are more forms available in the back of the room. Thank you, the three of you. How magnificent. Yes.